We have our scholars, like Professor Long at the University of Oklahoma. We have people who are on our side who go through the process trying to promulgate rules that help the investors. There's people in Congress. Congress right now is really looking closely at whether it's a good idea to have an industry arbitrator on panels. Congress is looking very closely at the whole arbitration process. There's hearings that are taking place as we speak, and most of those are from our industry group who promulgated it. On the other side of the coin, you have the defense bar. They belong to an organization called the Securities Industry Association. And they have their lobbyists, and they have their people, and they have their voice when it comes to these rules. And basically you have committees like the SICA, the Securities Investor Conference Association, the Securities Industry Conference Association, which comprises people from both sides of the aisle. You get the plaintiffs' people and the defense people. And when these rules are promulgated, it's always a compromise. For example, when the NASD Discovery Guide was promulgated, it was a huge compromise. They actually went on the road to places like Philadelphia, New York, and all over the country, and they said, well, what would you like to see in an arbitration discovery guide? What do you think are documents that are presumptively discoverable? And they heard from us at the claims bar. We actually had a conference on it, where the NASD informally called some of the practitioners and got their thoughts. At the same time, they talked to the respondents. People said, well, what would you like in a discovery guide? And a lot of folks are going to say that the discovery guide is somewhat lopsided. And we're going to talk about later why some of the documents that are in the discovery guide are so important and how they fit into various cases. But this new rule is intended to really stop the frivolous motion practice, the motions to dismiss that have been filed over and over again in arbitration, certainly past 2004. We've seen a lot more of those. And again, it sounds like a procedural device, a motion to dismiss, like a demur, or one for summary judgment. Those are just merely procedural. They don't affect the party's substantive rights. But if you got your case dismissed because of one of those, you wouldn't think it's a procedural rule. Again, the industry has their input into these cases, into these rules, the different promulgations that come out, different code procedures, and of course the plaintiffs' bar has their input too. And a lot of this has been changing over the years, and I think one of the big things that's happened at NASD, certainly within the last 2 years, is the reclassification of arbitrators. The neutral selection list started, I think it was in '99 or 2000, where the parties actually got a list in claiming a customer case of 10 arbitrators, public arbitrators, and 5 industry arbitrators. We get a list. It shows their backgrounds, where they went to school, the years they graduated, every job that they've had since school. Typically, a lot of these folks are lawyers, accountants, retired judges. And you get to see other arbitration awards that they've rendered, which are also available online. So you would get someone's resume, and says, gee, they went to University of Virginia, and they went to Harvard Law School, isn't that wonderful? And then you go on and you look on more, and so, but they worked for, Deckard, Price and Rhodes, or they work for some firm that has been associated with defense cases. They have a mindset. These people came from the defense bar. Or someone came from the plaintiff side of life, sole practitioner, worked for legal aid. You say, well, gee, that person's going to be sympathetic to my client's views because they look like someone who would sympathize with my client's claims. You look at sex. Are women going to be better in cases involving other women? Well, there's a difference of opinion about that, but generally, you want old arbitrators or young arbitrators? You want an arbitrator, panel that's very experienced, that has heard 30 cases, 40 cases, 50 cases, and has seen every atrocity known to mankind. There's nothing you can possibly show that person in your case that's going to make them sit up and take notice, because after all, they've seen it all before. Or do you want the novice arbitrator, the one that hasn't heard any cases? Your case, by definition, will be the best case that person's heard because they haven't heard any cases before. Then you look at the cases that they've actually set up for those that have cases. And you say, well, gee, this person award punitive damages, which are very, very rare in arbitration. If not, you can count them on one hand. Did this person provide attorney's fees? Did this person decipher the claimant more often than not? Or they decipher the respondent more often than not? I'll tell you firsthand that what you see on paper is a lot different than what you see in person. Because an arbitrator can look wonderful on paper, and you get in front of that person, and you find they're most defense-oriented. They don't understand the rules. They don't understand the rules of evidence. They want you to lay they won't accept a foundation for a document until you move it in.